Hi everybody, I am Alison Donnelly, Director at FSCOM, the compliance consultancy that specialises in helping payments and e-money institutions, and I'm a payments regulation specialist. I'm delighted to welcome you to this webinar. It's a slightly different format from our normal webinars. This is a discussion, but we have the opportunity to speak to some experts who've been involved in the recent Supercapital case, and in discussing with them what lessons could be learned, we felt that actually we could bring together our discussion and it would be actually really quite useful to payment and e-money institutions and indeed banking providers who offer safeguarding accounts. We all come at this from a slightly different angle. We all have our own bits of the jigsaw, and in the discussion we hope to put those bits of the jigsaw together to create a better, clearer picture for everybody. So I've introduced myself. Can I turn to my colleague Colin? Would you introduce yourself, and then I'll ask the others to introduce themselves. Colin.
Great, thanks, Alison. My name is Colin Sloan. I'm a senior manager at FSCOM, and in recent years, I've really been focusing on assisting payment and e-money institutions on the safeguarding issue, along with other matters under the payment services regulations and e-money regulations. So, looking forward to the conversation.
Thank you, Colin. And we're delighted to be joined by Kevin. Kevin is a practitioner and licensed insolvency partner, or the other way around, at Griffins. Kevin.
Yeah, my name's Kevin Goldfarb. I'm a chartered accountant and a licensed insolvency practitioner at Griffins. We were handling the administration of Supercapital Limited. I was one of the joint administrators with my partner Stephen Hunt, and so we were front and centre with our professional advisors in dealing with the issues that arose, and that's my role in this matter. Over to you, Alison.
Thanks, Kevin. And Alex J, you are a partner at Gowling's. Can you tell us about your role and introduce yourself, please?
Yeah, thank you, Alison. Yeah, I'm a partner at Gowling, and I specialise in insolvency matters and dispute resolution as well. And this was a case I worked on with Kevin and Griffins to address issues arising from the matter of Supercapital, which has been reported in a judgment. So we have some familiarity with the challenges that can face payment institutions in particular circumstances that we'll talk about on this webinar.
Thank you, everybody. I've been working in this area for many years, and I started my career in this particular sector at the FCA in policy and looking at safeguarding issues. One of the things that has sort of intrigued me from the beginning, and I've no real personal experience of, is how do firms go into insolvency, and what happens, what's the sort of first, second and third step?
Well, in the case of Supercapital, they had a problem of their own making, which has been in the public domain, in as much as that they accidentally lost some trust monies which they held in trust, and made what the euphemism was duplicated payments, and that led to them being in a position whereby they couldn't meet their obligations to their clients, and they were insolvent for a number of reasons, but mainly they needed an insolvency procedure to unlock the impasse that they had. They couldn't service their clients, and there were almost 1,000 balances that we were dealing with. Several hundred of them were large and active, and several hundred of them, 200 or 300 of them, were quite small. But we certainly had well over 400 or 500 active accounts, and so those accounts couldn't be processed. People who'd given them funds in return for other currencies couldn't receive their money back. That they were frozen, and that effectively meant that they were insolvent, and they needed a procedure to unlock that impasse. So that's how it happened. In the case of Supercapital, it wasn't that they had a huge institution and they weren't making enough money to pay their expenses. It was simply because there'd been a compliance issue, which is where FSCOM probably would come in, which is the rectifying compliance issues and actually avoiding the issues that actually turned up in Supercapital.
And if I may, there's a couple of important points relevant to the insolvency processes. Insolvency legislation is, of course, very detailed and deals with circumstances where, for whatever reason, a company can no longer pay its debts, and there is an insolvency professional appointed to deal with it. In the case of Supercapital, and where you have funds which are subject to various different regulations, in this particular case, the payment service regulations. But where you have that, you have a dual track, because funds which are subject to those sorts of regulations and are held on trust actually fall, strictly speaking, outside of the assets dealt with typically in an insolvency. That said, insolvency practitioners spend their lives dealing with property assets, well, property and cash assets, which have to be dealt with under various rules for the benefit of different stakeholders. And dealing with the assets that fall under the payment services regulations and form trust property is something they're uniquely well placed to address. You know, they can look through the different customers and the competing claims on those monies, and they're very well placed to deal with those issues in a sensible way, ultimately for the benefit of the people who those monies belong to. Typically, in a payment services institution case, that will be the clients who have put their money into that institution to be dealt with in whatever way the institution was operating.
That's almost a sort of a good reassurance, because I think we've seen so many difficulties with payments and e-money institutions in their ability to safeguard. There's so many issues and questions that have arisen over the years, and so much complexity to it that it almost takes you back to the fundamental point. This is about protecting consumers' money, and it's a very expensive and elaborate process to go through if it fails. And I think Supercapital is the first real example that we have of the procedures going before a judge and making an assessment of it. I know we've always talked about, the FCA gives guidance, the legislation set, it's fairly black and white to the extent that it's there. The FCA's given guidance. We'll never really know how it stacks up until it comes before a judge. So perhaps up to that point, could I have both of your assessment of whether it did really stack up and do the job it was intended to do? Alex, would you like to take that first?
Yeah, sure. And it's a very good question, because of course this was the first case that we were aware of where the payment service regulations in particular were looked at by the courts, as you've said. And there's a couple of points on that. The payment service regulations have a number of provisions in them that deal with circumstances where there is a gap in the customer funds, and it has some direction as to what ought to happen in that event, in particular the pooling of funds. What they don't go as far as doing is directing in any degree of granularity exactly how in this case, insolvency office holder in the form of Kevin, ought to manage the distribution process, ought to manage, in effect, taking those funds and working out what is a fair mechanism to return those monies to the clients. And there's a number of good reasons why it doesn't go into that, because legislating for every single eventuality and what may or may not happen in every particular case would be, of course, very complicated and no doubt unduly prescriptive. However, the law does have a number of principles that can be drawn upon, which allow the courts to fill the gaps in order to establish a sensible process to ultimately make sure that clients are dealt with fairly. And if you look at the decision that was handed down in Supercapital, one of the legal mechanisms that is drawn upon by the, by in this case, the Insolvency and Companies Court Judge Agnello, was that under principles applying to trust property, you know, this is property where one person is holding it, but it is not their property. It belongs to another, and they must deal with it in a way so that the interests of the ultimate owner are properly protected. And those rules are very draconian. They're very they impose a lot of obligations on the person acting as trustee. And drawing on those principles, what Kevin did and we assisted with was we established a mechanism to address the extent of the funds which the client monies which form part of a global pool of trust property, and to distribute those monies in ultimately what was a pro rata basis back to the clients in question. And the use of the pro rata basis is interesting, I suppose, from a legal point of view. It is a very common mechanism and very well trodden path that is used in insolvency generally, in the case of certain groups of creditors, where creditors can, in some cases, be treated equally, and monies in an insolvent situation will be distributed pro rata to the level of each creditor's claim. And those maxims have been drawn upon and applied, in effect, by the court here to have a system so that each of the individual customers in Supercapital received a pro rata share of the balance of trust monies. And as I say, you know, from a legal point of view, this is really a very good example of the court stepping in and applying existing legal principles to a situation where there is not a specific legislative direction for each and every action that must be taken.
That's really interesting, Alex. Just one of the points to sort of follow up on that. The FSCA sort of published temporary guidance for firms on safeguarding quite recently, and one of the parts of that guidance that you know, sort of stirred up a lot of discussion was that they used the language of trust in relation to the safeguarding account in the basically an appendix to that guidance. Now, as I'm sure you're aware, the word trust isn't used in the payment services regulations. Can you maybe give a view on how a trust applies in that instance, and maybe a bit of the legal background to that?
Yeah, I certainly can, and you're quite right that the word trust is not used in the payment services regulations, and I think it's correct to say, and I'll no doubt be corrected by people who can go and look this up, whereas I don't have this to hand as I'm speaking, but in, for example, the CAS rules, I think the language of trusts might be used. But the fact is, a trust can be created in law by operation of law. You don't have to say this is a trust for it to be a trust, in the same way that one cannot say this is not a trust to avoid a trust being created. A trust can arise by what's called the operation of law. And in fact, Judge Agnello acknowledged this point, as I recall, in the judgment she handed down. You know, the fact is that the wording of the payment services regulations is sufficient to make it clear that a trust is created. And the other point that was addressed in the judgment was that even though every aspect of how that trust ought to operate was not set out in either the payment services regulations or indeed, I think, the literature and the contractual material relevant in this case for Supercapital, that does not prevent the court from assessing what in fact the proper rules of the trust ought to be, and that's what the court did. And this is, this is the beauty partly of the English legal system. The court does have a degree of flexibility and what is called inherent jurisdiction to step in and to give directions that are necessary. In the case of trust law, which is what we're dealing with here, and also in other circumstances too.
There'll be further applications, I'm sure, coming down the tracks, and it'll be interesting to see the extent to which they build on Supercapital, or whether anyone tries to take a different approach. We thought that the system that we came up with Alex was sensible, and the court broadly were happy to approve it. And we found the court helpful, but I would say that because they broadly agreed with what we asked them to do. But it will be interesting to see whether anyone out there has got any different takes on the way of dealing with the problem going forward. We hadn't appreciated when we were appointed, and Alex was quick to bring it to our attention, we hadn't appreciated how significant and how important it was to get the approval of the courts to the way we wanted to deal with it. We had hoped that the regulations would cover it adequately, and it was when we started speaking to Gowling and they said to us, well, we really need the support of the court in doing this, or else it's just not going to work. The regulations per se won't answer the problems, and that's an interesting point. You would hope, and maybe that's just a forlorn hope of an insult, of really just a bean counter. You would hope that regulations would cover what turns out to be a fairly basic requirement. But hopefully, there is a path now, and people will either follow that path or something similar to it in the unhappy event that it occurs again. But I think it will occur again, and presumably your research in the industry, Alison and Colin, you'll know if there are other sort of similar cases coming down the tracks, or might be. Perhaps there are.
I think it's always possible. Of course, any business can get themselves into difficulty, and of course the impending economic crisis and whatever that brings, it makes it perhaps even more likely. And certainly the FCA is being very alert and aware of that. I suppose what's interesting from our discussion is you, Kevin and Alex, you have a view on how the courts and the legislation has dealt with it after the insolvency, whereas Colin and I are all about how we make sure that it's done right, so that there is a pot of money that can be secured by the court for it to be dispersed back to clients. Do you have is there anything that sort of jumped out at you about how firms should have been? And this is not, we don't need to personalize it to Supercapital, but is there anything that you identified that, or if they had have done that, or if that hadn't been done, that would have been problematical?
Well, I think in any situation, I mean, I know hindsight is wonderful. We've all got 20/20 hindsight. That I take for granted. But the truth is, and you'll see this from the work you do, that compliance issues are just in many cases best practice. And if people are following best practice, you minimize problems, and the way you minimize problems is to have a robust system with integrity. And so your clients will no doubt be looking for that. A pyramid of responsibility, no overrides, and I suppose we were talking about this, Alex and I, earlier on today. Part of the problem is because technology is moving so fast, and things that used to be the province of big institutions only can now be available to smaller organizations. The way you avoid problems and the traditional compliance method of avoiding problems that you'll be very familiar with, sometimes they just can't be enacted in smaller organizations. And in the case of Supercapital, we had an organization with balances into many millions, well into 8 figures. and it was really being run by a small group of management, and without specification of the problems to Supercapital. The way to avoid it has got to be, and this isn't an advert for you, but it's the reality. It's good regular compliance checks. You know, daily reconciliations. It sounds obvious. Daily reconciliations. You know, intermingling of funds, I know, is a hot topic for you guys. Well segregated and protected funds. Again, we had liquidity providers who didn't segregate. So the issues are obvious, but most compliance is obvious when you look back at what's gone wrong. And so those are the issues. Find the problem, trap it early, and try and create an organisation that minimises the problems. There you are, I've solved the problem in seconds. It's easier said than done, isn't it?
I suppose as well, just to add to what Kevin said, there's a degree of a sort of a carrot and a stick approach around that. You know, I obviously sit as a lawyer. I'm often called in when, you know, something has gone wrong. I mean, you know, we act, of course, as well, setting things up and trying to make sure that systems work properly. But for what I particularly do, I'm often called in when something goes wrong. But you know, there is a reality that where trust obligations are imposed, which they are, where client money is concerned, those are very significant obligations that are imposed on the people dealing with those monies. And where there is ever a shortfall in those monies, that's going to create a significant problem. And it's going to give rise to potential for liability of the people who are in control of those monies, having to have people called in to sort out problems after the event, you know, calling in Kevin and myself, even on a simple case, is going to be relatively expensive. And that is something that people in control of the money need to bear in mind, because you know, there is a danger if you are putting yourself in that position of dealing with client monies and you just don't do it properly for whatever reason, then there can be significant ramifications and significant expensive ramifications that can come down the track. And you know, in terms of, as I say, the sort of the carrot and the stick approach, the worst case scenario of there being a black hole and there having to be a Kevin appointed to come and sort it all out is going to be expensive and you know, potentially complex and long running.
Kevin, I think you were mentioning earlier as well, before we went on the recording, that the sector is small and the size of the sector isn't small, but there are small businesses within the sector. And you know, Colin and I work with clients at every range of this, so the startups right through to the well-established players. And there's a couple of things that I always sort of reflect on, and one of them is that the whole point of the second Payment Service Directive and the first was to open up competition. So we're actively deciding we want to have these non-bank players in, but we also want to have a level of protection and confidence in the sector. And the regulations itself have been in for, you know, good 10 years. So, but the focus hasn't always been on making sure this is right, and the scrutiny hasn't always been there, both internally and from external advisors. So I think there are still a lot of questions that are just kind of bubbling, and I wondered if I could put some of them to you to see if you have any insight, particularly from the more recent experience. And one of them is there's a point in the FCA's approach document about funds absolutely not being commingled at night. You know, segregation requirement in the legislation is immediately segregate, but the FCA goes further in saying there should be no commingling overnight. Sometimes that causes practical difficulties for our clients in being able to do that reconciliation and segregation exercise at close of business. And so I've never been able to find a really good reason why it's so important not to be commingled at night. And indeed, I almost think it's actually not probably possible that there's no commingling at night. What are your thoughts?
Well, I suppose the only solution must be to I don't know what the reverse of commingling is. Separation, it's got to be, yes. The only answer must be to separate the funds at the earliest opportunity. And therefore, the only issue is how you deal with that gap period when nobody can do it. Now, I'm not an IT expert, but I would have thought so much of this is IT based now. You know, we're no longer having a situation where people run down to banks with checks and pass them over the counter. I'm sure all of the funds we're talking about are received electronically. I'm sure there must be, oh, it's a horrible word at the moment, an algorithm that can take that money, strip it out, and put it somewhere such that the mingling hasn't happened. But I mean, that's something for the IT guys. But I see the problem, and I think there's always going to be, as I say, that period where the funds are mingled, because that's the nature of the problem. Give us our money, give us your money, we will take our fee and do things with it under protection. There is always going to be a period of time where there is this mingling. Maybe there has to be some sub-regulation that deals with funds that are caught in that difficult period. It's only going to be a small subset of the monies that come in, and a small subset of the money is under control for a brief period of time. But I know when we were talking earlier on, you spoke about sweeping the accounts on a regular basis, and that obviously is the way. I know from, if I can just move off of this, back into 2008, when we were all facing the possibility that certain banks might collapse, I know that various organisations were sweeping their accounts every half an hour to make sure that certain funds were not left with certain institutions any longer than they needed to be. So the principle applies. The principle's right, but you know, unless you can get a piece of IT that does it in nanoseconds, it's always going to be there, isn't it? There's always going to be a period.
But how important really is it? Because what always strikes me is, surely in a situation where it's customers' funds, and if it was brought before a judge, and other people who wanted the money were saying, "Oh, that belongs to us. It's got some profit. It's got some company funds in there." Surely the judge will say, "But actually, our priority here is getting the money back to the customers, because that's what the intention of the safeguarding rules are. It's clear that's what the intention of the firm was to do. It's just there's a little bit of over safeguarding it. The pot's a little bit too full."
Well, maybe the principle, and maybe Colin, I don't know if you feel this is oversimplistic, or Alex, maybe the answer is to say you're not entitled to a fee until you've removed the funds from a mingled state. In other words, there is no entitlement while the funds sit there. When you sit down and carry out an operation on the money, even if it's just splitting it, that's when you get your fee. So if there is any money placed into a segregated account overnight, you've got no right to your share of it until you've done something with it. Isn't it as simple as that? Sorry, is that oversimplification?
Well, I think that's definitely a solution that many of our clients adopt. So, I mean, really the question is, when does the money become the firm's own money? And you know, that's really a contractual matter. So I completely agree. But it's interesting because my understanding is that the FCA's kind of historic rationale for the commingling, rule, obviously it's derived from the regulation, but their interpretation of it was, well, the commingling will pollute the pot, and so in the event of insolvency, it could just pollute the funds and render it impossible to distribute the funds back to the customer. But I think what you guys are sort of saying from a practical point of view, actually, that's not likely to happen.
Yes, I mean, the public have to be protected, whether it's the public as an individual or the public as being a business. You know, all of the funds that we were looking at were by and large payable back to members of the public or small businesses. Some of them were larger, but nonetheless, it's about protecting the public. And if those funds are intermingled, and I guess intermingling simply means the company has got a call on some of it. As long as there's a contractual definition of the point at which it becomes separated, and this is where the lawyers come in, and Alex may have a view on it, there is no answer other than to say it's your money until we do something with it. And if it comes in at night and you haven't done anything with it, it's almost like we talk in insolvency about retention of title or reservation of title. You know, if you can identify that money and it hasn't been tainted, then come and take it back, or we'll pay it back.
Well, legally, you'd normally, and I appreciate it can get very complicated if you're dealing with large numbers of payments from different people and large volumes of money. But legally, it ought to be ascertainable what money is client money and what money is not, regardless of whether it's commingled or not. Now, I appreciate that unpicking that, if you end up in a scenario where somebody has to do that, might be complicated, therefore read time consuming, therefore read expensive. But legally, you know, your position will be what it is, commingled or not. There will be a legal answer to it. I suppose for a payment institution, the question is, absent breaching the regulations, if the regulations don't, you know, address this point, so you're complying with the regulations if you do commingle, or if you don't commingle, then, you know, as long as if you're complying, you're complying. But the question would be, if you allow a greater degree of commingling and you have commingled funds for longer, that somebody has to then allocate to the client account or to the office account, the longer you do that, the greater there's going to be of there being, the greater risk there is of a problem occurring. And if a problem occurs and you end up with a shortfall or some other issue with client monies, then because of the trust point we've just talked about, and the law will impose that trust pretty much regardless of what you say, you can't contract out of it, then you're going to have a problem. And I think, Colin, you mentioned that some institutions have a cautious approach, I suppose, where monies will be completely put on the trust account until you remove whatever element they're entitled to be paid from that trust account. That seems obviously a sensible approach. If organisations adopt a different approach, and I can imagine there would be a variety of reasons I don't profess to be an expert at all in as to why you might want to do that, but I can imagine there could be. If you adopt a different approach, then you potentially run a greater risk if something goes wrong. But that, you know, the law will eventually step in if needed to deal with that.
Okay.
That's really helpful. It sounds very much like, you know, there's a very black and white approach from the legislation and then the guidance. What you're saying, Alex, is it will be resolved, but what we're looking to do is minimise the cost of the resolution of it.
Completely right. No, completely right. And I can imagine organisations want to minimise their risk of there being an issue, and the way that they deal with funds which are commingled, you know, it seems to me they can reduce their risk of there being an issue by having a system which steers much more to the side of looking to protect client funds and keep them segregated until you can properly, you know, remove any element that is going to be treated as company funds. You know, that is a much more cautious approach. And that was the approach Colin was saying some organisations do. And that's my only point is from avoiding getting into problems which can be legally expensive, etc. That is a very eminently sensible approach, it seems to me.
The practical problem, Alison, just to cut across you there, the practical problem, and we see this across insolvency generally, not necessarily just with financial institutions, is that, of course, when things go wrong, these fine principles occasionally fall by the wayside. And sweeping, which is meant to occur every few hours, doesn't occur for days. I'm exaggerating perhaps slightly there. And so the problem you have in any insolvency situation is often that when things go wrong, you know, people drift away, employees with responsibilities are not motivated or just don't turn up. And so the problem is not how you deal with it in organizations that are well run and doing well. They will deal with it properly on a timely basis each day, several times a day, whatever, first thing in the morning. The problem is how you legislate, and this is what Alex was talking about, how you legislate for the ones where it goes wrong. And the problem with the ones where it goes wrong is that there's going to be a disproportionately expensive solution, because you're unpicking someone else's problem. You're unraveling a knot that someone else has created.
And Kevin, I've always said that's the fundamental difficulty with safeguarding, as being the consumer protection method that we sort of have to rely on, because I presume you could be a very good firm and do everything right every day up until it starts going pear-shaped, which could be just, you know, external economic factors that are making the business go bad, but people then will drift away, and the last man or woman standing on the day that it goes bust, they're the ones that are having to, you know, segregate and sweep and all that. And are they really going to be doing that on that day? I'm sure there are many very, very, you know, respectable and right-thinking people who would do it, but they could be forgiven for having other priorities that day.
I guess, yes, that's right. And from your client's point of view, presumably their concern are the people they're acting for, because many of your clients are safeguarding assets and they're helping the payment service providers. They're working with the payment service providers. We found that the safeguarders, the banks, were very helpful, and they just wanted to get it right. You know, we found them very cooperative by and large. And so I think everybody wants the system to work, because that's the way you retain faith in the system. Again, you know, you've got to look for the legislators, the regulators to set the framework in place that deals with what happens when it comes off the tracks. And I don't know, that we know we've had the insolvency legislation, the most recent insolvency legislation for long enough, and even then we find arguments. That's what keeps insolvency practitioners going and their legal advisors going. So, you know, there's no answer, but there's just things we can do on a regular basis to keep it as safe as possible.
That's a really interesting point. So there's a lot of there's not very many banks who are willing to provide safeguarding accounts to non-bank payment service providers. So, you know, it's difficult to get banking arrangements. So it always feels a bit of a luxury to ask firms, you know, why have you made the choice of going to this payment service provider, this bank, over another bank? What will happen at the end of this year, when we really properly move away from Europe, is that the choice of credit institution that you could go to broadens out to include those in OECD jurisdictions and the OECD equivalent jurisdictions, so much broader. The recent sort of Wirecard situation, and you may not have followed the Wirecard situation in detail, but there was a point when the FCA stopped action on those firms, that business, and required all the funds to be moved. And so it's an interesting question about whether it makes any difference whether you're safeguarding providers in the UK or in the EEA or further afield when that option becomes available to us. Was there anything in the Supercapital situation or your broader experience that would sort of give a thought to that?
I don't think there was anything particularly in Supercapital. You know, the market is getting wider, is what you're saying, because of the Brexit, because of the European Union situation. You know, what could possibly go wrong? You're taking your market from being a defined group of countries to presumably an unlimited group of countries.
There are some constraints. There are some constraints on it. They have to be, you know, meet certain standards, but it certainly broadens it out.
Yeah, that's where I'm sorry. That's outside of my knowledge. Alex, I don't know, because I know you're an international firm and presumably you're providing this advice to outside the EU as well.
Well, a lot of the work that I do actually involves dealing with international asset recovery cases. We do a lot of work where you're tracking down funds, often derived from Ponzi schemes, which is an extreme example, of course, of a payment institution, I suppose, going deliberately wrong. So, we've acted on the Alan Stanford and aspects of Bernie Madoff and others, no doubt, of a similar ilk. The short point is that where I'm not an expert on what organised institutions can at present use, but if you have ones, broadly speaking, within the EEA or the European Union, what you have within the EU at the moment is a fairly well orchestrated system to deal with disputes being managed across member states. You have rules about service of proceedings, and there's harmonisation of insolvency rules and all of this sort of stuff. And let's not talk about Brexit. Hopefully Brexit won't completely destroy that. It would be a shame if it does, but we'll have to see. I'd be surprised, but we'll have to see. If you have suddenly the ability to deal with organisations from across a much wider spectrum, I'm sure 99% of those will be absolutely fine, but you do, of course, have the potential for organisations in jurisdictions where it is a lot harder to take action. For example, if the FCA wants to cooperate with its equivalent body in certain territories, it's going to be a lot harder than cooperating with a body within the European Union, for example. The same applies for any insolvency proceedings. You won't have the same degree of harmonisation of insolvency processes. It will depend on a state-by-state, a jurisdiction-by-jurisdiction approach. So does that create the potential for more problems? I think the answer has to be yes. It doesn't mean because you're going outside of the EA it's a problem, of course not, but it's going to significantly widen the potential for there to be much more complicated cross-border issues which will arise. That's something that's going to have to be looked at fairly closely.
And just actually touching on that, presumably that will also impact the whole trust issue, because it would depend on what jurisdiction's trust law applied, and I would imagine it would make it all the more important that the terms that the payment or money institution has with the credit institution in the third country were all the more tighter.
Well, it will depend on whose law is being applied. It will depend on which jurisdiction's law takes precedence. Obviously, different countries have different rules about the operation of trusts. Different countries have different rules about which creditors in certain scenarios get paid out first. For example, India, for example, has a different approach in terms of priority of payment to creditors and insolvency situation than you have in the UK. There are differences between financial creditors, banks effectively, and general creditors that you don't have in the same way in the UK, and every country will have its own rules. So that will need to be looked at very closely, and people will want to make sure that you are clear whose rules are being applied at all times. And I'm sure customers would want to make sure as well that they know whose rules are going to be applied, so they can have certainty as to what would happen in a sort of worst case scenario. But you get into some, this is in the territory of complicated cross-border legal issues which need to be looked at very closely on a case-by-case basis. They're not straightforward to deal with.
And again, it's another issue for any payment or e-money institution to consider when they're selecting their credit institution for that purpose. Thank you very much. Before we finish up, and it's been a brilliant discussion, but I'm quite interested in one of the issues that exercises a lot of our firms is the issue where one payment or e-money institution uses another to transfer funds, because this creates a chain, and in that chain situation, we have both players have to safeguard the funds. The first one is safeguarding the funds for their customer, and then the second one is safeguarding the funds for their customer, who is the payment or e-money institution, the first firm. And it creates a situation where there's money being held in safeguarding accounts, and then duplicate funds being used to be transferred off to the beneficiary, which, as you can imagine, sort of is costly, and you'll be aware of the sort of sums that can be transferred in these kind of transactions. We think that there is a point that insolvency legislation could be changed to make that a more feasible process, where the second firm, the middle one, could safeguard for the underlying customers. And I just wanted to put that theory out to you to see what your thoughts are.
It doesn't, the insolvency legislation, it doesn't jump out of the page at me as being a solution to that kind of issue. It's more contractual, legal. Alex, can you see any way in which?
Well, you know, without having looked at the specific issue, it's quite difficult to give an answer. I'm guessing it must relate to the classification of who is deemed to hold particular assets at particular times, which could have a difference if there is an insolvency situation. Although, of course, the trust principles, as we've described, if assets are held on trust by a particular party, then that creates a slightly different argument and a different set of criteria you need to look at where there's an insolvency situation. So it's one I think we'd be very interested in the thinking behind which particular rules are impacting this problem, and I'm sure we could give some thought to it offline.
A second webinar, perhaps, on that very subject.
Oh, absolutely. Thank you. Thank you for that, for volunteering, Kevin. I think we've had a great discussion. I really appreciate everybody's thoughts and input. I want to wrap it up there with thanking everybody, but I do want to give you all one last opportunity to say what's the most important thing that you've learned, or that firms should take away. What's your takeaway from that? And before I turn to each one of you in turn to give you time to marshal your thoughts, I'll tell you what I think, what I've heard today, which has been really good news, is that the safeguarding arrangements do work in practice, that the funds may well have been were diminished due to the costs associated with having to get them the resolution as to who owned what, but you know, it worked, and I think that you know, comes as a good relief whenever you know how much effort has gone into getting arrangements in place. But you know, as we've discussed today, there's clearly things that firms can easily do and things that might be a bit more difficult to do to make sure that the pot is as secure and well funded and easy to disperse as possible if the terrible situation arises where we have to wind down the firm. Kevin, can I turn to you next?
Yeah.
And Kevin, thank you very much for contributing.
It's been a pleasure. I think the lesson is that we're just at the beginning of this. The fact that you said that you thought this was one of the earlier decisions in this sector, the fact that it's one of the earlier decisions in the sector tells me that we're only on the first step of a path. And what I've learned is that the industry is going to develop, the regulations around it are going to develop, and we've got to try and make sure that as we go forward, there are less needs for the courts to get involved. But I don't see that happening in any time in the near future, which is good news for various parties, including legal advisors, of course. But it's been interesting, and as I say, I think there's going to be more. I'm not pleased about that, but there will be more.
The reality. Thank you very much, Kevin. Alex, can I turn to you, please?
Of course, yeah. I mean, I agree with Kevin that you know, this is one of the first cases in this particular area, and I think unfortunately there will be more cases where this sort of issue becomes a problem. I suppose the encouraging thing from a legal standpoint is there are, particularly in a common law jurisdiction that we have certainly here in the UK, where you do have inherent powers of the court and both an ability and a willingness to step in and to ensure that fairness is done, in this case with trust property, but there are also other areas where the court can step in and apply equitable principles to ensure fairness. It's encouraging that I certainly think, and I'm sure Kevin agrees, that the outcome in the Supercapital case was one that was ultimately a good and the fairest outcome we could achieve for the creditors, and that is encouraging for future scenarios, it seems to me. And if you can hear occasionally my daughter crying in the background, I can confirm that she agrees also that the trust rules are very well established. That's what she's saying.
It's a cry of concern, and hear, hear, Paddy, and hear, hear, Alex. We much appreciate your contribution. Thank you so much. Colin, would you like to have the last word there, please?
Sure, yeah. I mean, it's just been an interesting discussion on the application of trust law and the, I suppose there's to some extent, even where the firm gets it wrong, the court will step in, which is encouraging. Though, good point made that, the adherence of firms to the regulatory requirements and guidance will make that whole process less expensive and cumbersome if the worst does come to pass. So, very interesting discussion.
Again, thank you all very much. Goodbye.
Thank you.
Thank you, Alison. Thanks very much.
Bye now.